check 1 2. Hello. This is Just Human episode 351. And today I have a couple updates in some cases that aren't the Comey case, but mostly I have updates in the United States v. Comey case. There's a bunch of filings that have happened, probably like 70 something pages of filings, and they're significant filings. Now, I've made some shorter videos that go over a couple of those filings, but I wanted to go through them page by page in this episode. So we're going to hit those here pretty quickly. First, I want to say thank you to everybody who is a subscriber over on YouTube or Rumble or Substack, wherever you follow me and subscribe to my stuff. Really appreciate it. Everybody who has been following me on X knows I've been threading more and more, and I appreciate everybody liking and commenting and sharing those. It's good. I'm glad that X has made some changes that save your draft threads a little bit better and also link them to your phone. So I've been threading more and more, and I really am enjoying it. Over on Substack is where I put out the episode and the podcast. And if you're interested in getting this show as a podcast, whether it's on Apple or Spotify or Podbean or however you want to listen, you can also listen to the Substack app. Substack is the way to go. And Substack is also the best way to support what I do. It's about $7 a month. Basically, you're buying me a cup of coffee and you're helping me buy court documents off of Pacer, where I spend a lot of time digging around. I just spent about 30 minutes looking for a hidden search warrant case that is related to the Comey indictment. And I'll get to that more in a minute. Also, over on YouTube, I've just passed 500 subscribers, which is awesome. That's one of the things you have to do in order to get monetized over there. The next step is that I have to get so many thousands of watch hours, and I've got a few thousand watch hours so far, and I need like a couple thousand more, and then I'll be eligible for monetization. We'll see what happens with that, but thank you to everybody who's subscribed over there. I do have a playlist over there for United States v. Comey and United States v. Bolton, and a playlist of clips, and I'll keep adding those. One thing I would like some feedback on, I'm not really liking how the podcast thing works over here, because I have, what it's doing is it's creating a video for the podcast and a video for my episode. So like these two right here are the same thing, but one is just the audio and then one's the actual episode. And so I'm not liking how it does that. But when I go to podcast, it has both. So I think I must have set something up wrong. I'm not sure. I'm trying to figure it out. So I don't know. I don't know if anybody's actually listening to me on podcast form on YouTube. I know I never listen to anything on podcast form on YouTube, but it's available. So I feel like I should do it. But anyway, if you're confused by this, there being two videos for each full episode, that's what's going on. It's not that the video is frozen on this version. It's that YouTube is taking it as a podcast, but creating this image instead of keeping my logo on it. I don't know, man. And I'm also doing the same thing on Rumble. I'm uploading the clips of these episodes to Rumble, and they go into their own playlist over here that's for Comey. And I have a lot more playlists over here because I've been there longer. One day YouTube will look like this after I just keep uploading. So if my voice sounds a little bit already gone, it's because I already recorded those clips that I just showed you. Okay, let's do some of these smaller updates. Do you remember the case against Smartmatic, which is, well, originally was the Smartmatic execs. Now it's actually a case against the Smartmatic, the company. So we had an update a couple weeks ago. I talked to you about a new superseding indictment in a case that's called United States v. Bautista. Bautista is a guy who in the Philippines was the head of their election board. And that election board is called COMELEC. It's Commission on the Election. And then those words are combined into COMELEC, okay? Commission, election, combined into one word. And this guy, Juan something Bautista, was the head of that, was the chairman of it. And that board was charged with locating voting machines and issuing contracts to voting machine companies to then use them in the 2016 election in the Philippines. And it was the national election. It was for president and other offices. Well, in order to get those contracts, which the company Smartmatic really wanted, execs at Smartmatic arranged some bribes, millions of dollars in bribes to this guy Bautista. And they got caught. They used a bunch of shell companies. They used code languages. They emailed about it. And the US government has all those things. And because those transactions, those briberies, those bribes, I mean, because they went through banks located US side, and because Smartmatic is a company that has offices in the US, they've been indicted in the Southern District of Florida. Now, this case first came out back in 2023 or thereabouts. Yeah, September 2023, I believe. And I've been following it ever since. And we've had an update on it on my show here and there. But the case has been long to reach an actual trial. And it's going to take a bit longer because a couple weeks ago, they added Smartmatic, the company, as a defendant. This case already included the Venezuelan co-founder and executive of Smartmatic, a guy named Roger Alejandro Penate Martinez, and then also Jorge Miguel Vasquez and Eli Marino. These people have been in custody, but Bautista was a little bit more difficult to find. And as far as I know, he's not U.S. side yet. Last I heard or read in the case, he was in Canada and they were working to extradite him to the U.S. But for some reason, Canada maybe isn't playing ball, or Bautista just has an incredibly good lawyer. I'm not really sure. But the update for you in this case, which, by the way, this was hundreds of millions of dollars in contracts for tens of thousands of voting machines to be used in the 2016 Philippine election, and they were used. The problem is they corruptly acquired those contracts, and they engaged in bribery of a public official in the Philippines, and they conspired to violate the Foreign Corrupt Practices Act, and they conspired to engage in money laundering, and they did launder money through companies that had various weird names. They laundered it through I think a couple of them were just totally fictional. You needed a chart to keep up with all of the ways they moved this money around, but it ended up being $180 million worth of contracts and a couple $1 million over to Bautista. Thank you very much for helping us get these contracts. Now, what happened this past week is that voting machine company Smartmatic made their initial appearance in federal court. Their next appearance, which will be their arraignment, is set for November 20th. And then after that, we'll have the back and forth and we'll see where the trial ends up going. It could be there might be some separation of defendants. They might file to sever the case. But this is a case worth following. And I think it's a case that, well, how do I say this carefully? So a lot of people think a lot of things about Smartmatic and the business that they're in. Okay? We're all aware of that. There's a lot of conspiracy theories about Smartmatic and the activities they engage in. This case doesn't tell you anything about that. And this case is not about that. This case isn't about the outcome of the election. This case isn't about anything to do with the machines other than the contract to get those machines and then use them in the 2016 Philippine election. So this is really a public corruption case and a corporate corruption case. It's a case about bribery and a case about money laundering. That's the criminality being alleged here. That's the information that's on the docket. And I would just caution you to not get out over your skis when it comes to talking or posting about this case, and to be careful about accounts who do, which there are a lot of accounts who do. I've been following this case since the very beginning of it, and it's always been about bribery and money laundering and corruptly acquiring contracts for an election. And so far, not anything else. I'm not telling you that who you should follow or who you should engage with or anything like that. I'm just saying that those are the things this case is actually about, per the documents in the case. And people who make allegations that it's about more than that, they're not doing so based on any document that's actually in the case file. And I feel like you should know that. Okay, next update. And all of these updates videos I'm uploading today are going to go into episode 351. Next one is, you remember, it's been a while. It was back in 2022. There was a case against JPMorgan Chase Bank that was filed by the United States Virgin Islands. Okay, we kind of forget about the Virgin Islands, but they're part of the United States. In fact, I mean no offense, but the only time I think about the Virgin Islands really is when it has to do with Epstein, or it has to do with their incredibly how do I say it? Very annoying and stupid representative that they have in the House, who seems to find her way into hearings all the time and make a scene. But you may remember that the Virgin Islands brought a case against JPMorgan Chase Bank back in December 2022. And it was over their business dealings with Jeffrey Epstein, and how the bank was aware of Epstein's plea deal and his activities and the allegations against him. And they continued to do business with him to the tune of millions and millions of dollars. He had accounts with them, and they had meetings about who he was and whether or not they would continue with him, and decided to continue with him. And the United States Virgin Islands, plus some Jane Does, decided to sue Epstein, or rather Epstein's estate, and also sue the bank, JPMorgan Chase Bank. They also sued Deutsche Bank and some others. This is one of a number of lawsuits that are out there, both civil and criminal, right? Well, this case ended up going on for a couple years, and I think it was earlier this year they reached a settlement. Now, the complaint alleged, like I said earlier, that JPMorgan knowingly facilitated, sustained, and concealed the human trafficking network operated by Jeffrey Epstein. And 9 months after the case was brought, so this would be in 2023, they reached a settlement for $75 million. And I remember sharing information about this case as it was going on. And I remember big excitement when it came out, when it was first brought. And then I remember big disappointment and allegations of collusion and deep state and cover up and all those things when it was settled. But now we can go back to celebrating, because before reaching settlement, a lot of exhibits were filed in this case. Financial exhibits, documents. I like documents. Over 100 of them were filed. And after it was settled, the New York Times, the Wall Street Journal, and other outlets sued to have these exhibits unsealed. And they have been. 135 of them. So all of these are now unsealed. You can go through and click on all of them and start looking at what they are. And I've done that for a few of them. I have to admit, I haven't found anything that I was just like, whoa, this is so crazy. But I did immediately find this one, which was an email exchange amongst the people in JPMorgan Chase Bank after it came out that this is from October 10th, 2007, and it was the public reporting about Jeffrey Epstein's plea deal. And it's a person in the bank asking, can you email me the recent newspaper article about him shortly pleading guilty to the charge? I want to send it to Andy and Ann and all these other people. Ann and Jess, Mary E, and Brent are meeting this afternoon to discuss. I mentioned about the PCS account. I also mentioned this meeting to Randy. It shows that there was a conversation and an awareness amongst the people in JPMorgan Chase Bank about Epstein and about that 2007 plea deal and the charges he was pleading guilty to, which means they knew the criminality he was engaged in. and they chose to continue doing business with him. That's just at a minimum what it means. There's so many documents here, and it'll take a while to go through of them. Are these more? There's more. On Halloween, even more were unsealed right here. So here's the stuff that was unsealed when I made that thread. 135 documents. 135 exhibits. And then we have 11 more. So now it's 136 that have been unsealed. So I put a link on my thread here over at @RealJustHuman on X. It's right here. If you want to go and find my post, you can find that link and you can go through all the exhibits yourself. You can also just go search on Court Listener, United States Virgin Islands v. JPMorgan Chase Bank, and you can find this case and you can find these exhibits. I'll keep perusing through these, see if I find anything that really stands out, and if I do, then I'll post them to this thread and they might wind up in a video. Just to give you guys a couple examples of some of the types of documents that are in these exhibits. These are exhibits that were put together by the U.S. Virgin Islands, their AG, in their suit against JPMorgan Chase. So these are stuff that are meant to show, let's just call it bad behavior by JPMorgan Chase in their handling of Epstein's accounts. And so some of the things you see in here, some of these exhibits, are suspicious activity reports, also called SARS, okay? And this one right here, as well as the next one, this one actually names Jeffrey Epstein as who it's about. This one is about an account, is who it puts in the name section. It gives an account number, right? When you scroll down and you look at, well, what is this SAR, the suspicious activity report, about? Keep scrolling. There's JPMorgan Chase giving all these identifying information. It's about Harry Beller. Well, Harry Beller, along with Richard Kahn, I believe is the name, are some of the accountants who worked for Epstein and are involved in thousands of transactions of moving money around, including to offshore accounts and accounts in the U.S. And we're talking about not millions of dollars being moved over the years, or tens of millions of dollars, or hundreds of millions of dollars. We're talking about over $1 billion being moved through Jeffrey Epstein's various companies and accounts that he had with JPMorgan Chase and other banks. He was a high-rolling client. I believe in here it gives you a reason for the suspicious activity. It gives it a name. I know the other document does. There's Indike, Darren Indike. That is the guy who manages the Epstein estate. It's somewhere here. I know it is. So far, it's just all this information about him and about these accounts and which accounts they're talking about. Where is it? There's Richard Kahn. There's Bella Klein, another one who handled his money. And I swear there's some suspicious EFT wire transfers is checked. Changes in spelling or arrangement of a name is checked. There's a reason for the suspicious activity. This is from 2007. 2 or more individuals working together. There it is. There it is. Possible procurement of certain types of services. Right there. Now we go to the next one. This one actually has Jeffrey Epstein's name. It is from, well, we'll get a date here, down here somewhere. More of the same types of information that was in the other one. This one, it's redacted who the person was that the money went to, okay? But look, birth year is 1985, and the gender is female. So you do the math. If this is a 2007, like the other one, you do the math on how old she was at that time. And then Epstein, Another one, female, birth year 1979. Let's see, suspicious activity information. Let's see if anything's checked here. Changes in spelling or arrangement of name, two or more individuals working together, and other. And what's written in the other box? Possible procurement of services. Now, another example of what's in here, types of documents that are in here, is this report. I think this is an internal document. Yeah, this is an internal document that has to do with, it's a KYC profile and anti-money laundering. See this right here? AML. AML means anti-money laundering. And this is a flagging of behavior on this account and Richard Kahn. And it's talking about how, hey, we think there's some money laundering going on here. There's some suspicious activity. And we're escalating this because we think there's a direct match with ownership to a previously closed account that was terminated by the firm. Based on the aforementioned information, this escalation will be submitted through closure process due to the previously identified anti-money laundering risk. And it names Richard Kahn and Epstein right here. It says Epstein's funds potentially assisted in facilitating the trafficking ring and is one of two, and this guy, Kahn, is one of two executors of Epstein's will. This document, I think this is FinCEN. No, this is the due diligence report from JPMorgan Private Bank. Okay. This is their own due diligence report where they're examining their handling of some of his funds. And look, it has all of these people and accounts and entities that he had with them or that they moved money to for him. And down here, it gives a description. Summary of findings. Epstein is an existing client of Private Bank. In years past, he was an active brokerage client. Formerly, he was a money manager for high net worth individuals, most notably Leslie Wexner of Victoria's Secret fame and Bed Bath & Beyond brands, all those. Wexner was a JPM client and then retained Epstein as his advisor in the late 90s. Wexner terminated his relationship with Epstein in February of 2008. Mr. Epstein is well known to several JPMorgan Chase private bank employees and to Jess Staley. Mr. Epstein was convicted of a felony charge in 2008 and was to serve 18-month prison sentence. Jess Staley conferred with Stephen Cutler, and a decision was made to keep Mr. Epstein as a client. June 18th, 2010, Mr. Epstein is currently serving out his house arrest. Our view is that Mr. Epstein has served his time and is completing his duties to society. We are assessing the situation closely and monitoring the occasional news story regarding Epstein and civil lawsuits. Mr. Epstein is managing his own personal wealth. January 27th, 2011, update. A few news stories during 2010 connect Jeffrey Epstein to human trafficking. The coverage team, along with Catherine Keating and William Langford, all met to discuss the situation and agreed to enhance monitoring and documented a discussion with the client. Jess Staley discussed the topic with Epstein, who replied there was no truth to the allegations, no evidence, and was not expecting any problems. We will continue to monitor the accounts and cash usage. Here's another due diligence report. And this one just is grabbing a newspaper article from 2006 and putting it in here as part of their reporting so they can follow information in the public arena about their client. Here's another one doing the same thing, August 2006 article. Here's the FinCEN report, which FinCEN, if you don't know, is Financial Crimes Enforcement Network of the United States Treasury Department. And this is a 2002 report right here on Harry Beller. This might be a number of reports. Here's one on NES, one of his LLCs. Here's another one on JPMorgan Chase Bank. And it says, yeah, they're tracking wire transfers to these different accounts and these different amounts. And the checks were being cashed by an employee with the exception of the $40,000 check, which was cashed by Harry Beller because of the authorization needed. The account being funded by wire transfers from an account in the name of Epstein at Palm Beach National Bank. The account has received 10 wires totaling over $500,000. I think it says somewhere money laundering on here. I feel like this was the one that said specifically money laundering as what they were monitoring for. There it is. Suspicious activity information, $194,000 moved between January and March of 2002. Money laundering / structuring. Another FinCEN report. And this one also money laundering. Looks like it's for that same year in a similar amount, but it's later in that same year. Same thing here. Another report. And then this is another example, my last example from these exhibits. This is a deposition that was taken with someone from the bank, and they're asking him, like, they're about a rapid response meeting they had because they were aware of the trafficking cases coming out of the private bank. And the guy says he doesn't remember. But he's like, yeah, what did we just see, guys? We just saw these right here where they're talking about it. So maybe this person, maybe he wasn't in on the email chain. Let me see what his name is. This is a videotaped oral deposition of Bonnie Perry. That was from May 10th, 2023. And they're asking this person about how do your rapid response meetings go? When do you escalate a risk assessment? Move it up and consider closing an account. And I think the reason they grabbed this one, I don't think it was to catch her in a lie. I think it had to do with her awareness of who knew what. Let's see. Yeah, he's asking about who got the control group risk management group. Yeah, that's what this transcript is about, is I think the awareness that they had. So those are the types of exhibits that are in here. While I'm have the record button depressed, I'll open up a couple more and just scan them. Here's another one that's an email about a Gawker news story. FBI set to reopen the case. This is from March 2011. And this is being circulated by people in the bank. JPMorgan Chase right there. Philip DeLuca, JPM Chase. But they chose to continue doing business with him. Here's one, Ghislaine Maxwell, Air Ghislaine Incorporated, $201,000. This is an internal JPMorgan Chase document. This one may just be proving that this account existed and that this much money was transacted across it, because it doesn't look like it says anything suspicious or like has some sort of summary that we're looking at something weird here. Yeah, I think that's what it is. It's just meant to show an account and how much money moved through it. Another suspicious activity report. Advisory, human trafficking. Another internal email between Bonnie Perry, that's who we just looked at, that deposition. It's from 2006, and Mary Case. And due diligence report, DDR. It's about updating a due diligence report looking at Epstein's activity. Another email. This is from Jess Staley to Oliver Gavinci, both JPMorgan Chase people. Read Jeffrey Epstein. Oliver, or Olivier. Ghislaine is a good friend of one of our very big clients in the U.S. This is from 2005. Can we please try to help her? I think she's looking for a basic checking account. An email from Jess Staley to a person saying, please help Ghislaine get a basic checking account. Jess, I put a call into Jeffrey Epstein yesterday and forwarded Olivier's contact information below. If it is for Ghislaine Maxwell, we already have an account open for her on our team and can purchase STG and euros here if this is all they are looking to do. Signed, Tad Smith, JPMorgan Chase. Cecilia of JPMorgan Chase, maybe? I don't know. The email is redacted. Cecilia just said that Jeffrey had an associate who was looking to open a private banking account in London to hold sterling and euros. Do you have any further information? Another email between JPMorgan Chase folks. Forwarded, Jeffrey Epstein is the subject line. Duffy agreed with moving off of Justin. This is 2013. Suggested using New York tri-state exec to Jeff, but he would prefer to keep it in the market. Would you be comfortable with our moving this relationship off of the banker's name and putting it on Tad? Keeps it in the region and market, but removes one of the banker's scorecard. He was the banker on the account briefly, and with our decision to exit, it might be fair to immunize Justin. This is a client that we fired. I believe John called the client the last couple of weeks. Let's see. Here are the numbers for Epstein. Since John just called him to exit the relationship, I assumed that it would take 3 months for him to move it out. And I list some of the $72+ million a year currently assigned to Justin Nelson. So this is them talking about exiting Epstein, but it kind of sounded like they were talking about moving it to a different bank so that they could get off the scorecard. I'm not sure I exactly understand it, but agreed that it should not be on the team. Problem will just get worse. Let's move to me. Interesting. So these are the kind of documents that are in this, and that the government would have used if this had gone to trial and all these exhibits would have come out. We'll see if there's more exhibits that are still sealed. We'll see if a few more end up getting unsealed in the future. But this is a great example. I've talked about this before, how sometimes the direct action cases give you a bunch of information, but sometimes it's these other ones that are they're kind of at the flank of the issue, and ones that track the money, they almost always end up telling a more complete story, right? Follow the money, and this is one of several cases that were brought against banks who did financial transactions for years with Epstein, even past his plea agreement, and didn't get off of it until 2015 or so, after he was getting exposed, and then even some of them continued until he was indicted. Okay, time to get into the filings in the United States v. Comey case, page by page. Yesterday, I did some recording, and a little bit the day before, and those videos wound up being some shorter clips. One of them has to do with Comey's motion to dismiss for fundamental ambiguity of the questions and that Cruz asked him, and the literal truth. And I used my thread plus some other sources to make about a 40-minute video, which I uploaded to my sites. And then I also did about a 15-minute video that is based on Comey's motion for disclosure of grand jury materials. I tried to make those as quick as I could, like time-wise, how long the videos last. But I didn't go through those filings page by page. Since making those, and like kind of throughout the day yesterday, more filings hit the Comey docket. It was a very busy Monday, and the government has finally stepped up and responded to what I characterized as the body shots and head shots from a boxer onto a covered up Lindsay Halligan. You know, it's an imperfect analogy to think of boxing and lawfare here, but what I was trying to say is that this docket has been filled with motions filed by almost entirely Comey's side, and then friends of the court, amicus briefs that are pro Comey's positions, right? And finally, starting on November 3rd, and I think maybe even on a little bit on Sunday, there was one by USA. Yeah, on Sunday, there was one by USA. The government started responding. Prosecutors started responding and filing some big motions. And those motions are really interesting. They're worth a read page by page, and they're also very compelling. And while some of my audience may have been, I think a lot of my audience disagrees with my assessment of Comey and would rather me be sitting here saying, "Oh, Comey's going down," or kind of taking that attitude about it and conveying that kind of a message. I think you'll find that these motions have shifted me. Especially the one on the appointment of Lindsay Halligan. I find it very compelling, and it's basically changed my mind. Or at least I don't know if I'm ready to say it's changed my mind, but I'm close to saying it's changed my mind on the legality of her appointment. So what I'm about to start doing, this is the first recording of a series of ones I'm going to do that go through these filings page by page. Some are short, but some are pretty long. Before we get to the government's ones, there are I think there's one or two from Comey. There's two from Comey that we're gonna read through page by page. And if you want a shorter version of some of these, well, my YouTube page and my Rumble page has the shorter versions. This is going to be the long version, and this is what's going to go into my main podcast. So welcome all you document nerds. This is where we get into the documents page by page. All right, first thing that I want to make you aware of. Things are going to get just a little bit more confusing than they have been with this case because a third judge has been brought in to handle some of the issues. This is going to be Judge William E. Fitzpatrick, and he is going to handle the motions that have to do with the implementation of a filter protocol. There's going to be a hearing on that tomorrow. As of this recording, it's going to be Wednesday, November 5th. There's supposed to be a hearing on this issue, and it's going to be about the protected material that they're discussing and the quarantine material, and he's going to hear from both parties on the subject of implementation of a filter protocol. So we have Judge Nachmanov is the Eastern District of Virginia judge who is handling the criminal case. He's going to handle the trial and motions having to do with the trial and all of that. And then there's Judge Curry. I don't know if his name is like two last names, McGowan Curry. So I don't know if it's supposed to be Judge McGowan Curry or Judge Curry. I'm not. It's right there. Judge Cameron McGowan Curry. So I don't know. It's not hyphenated. So I don't really know. So I'm assuming it's McGowan Curry. Anyway, that's a senior South Carolina judge who's brought in to handle the motions that have to do with the legality or the questions of Lindsay Halligan's appointment. He's handling those. And then Judge Fitzpatrick, which forgive me if I call him Fitzgerald sometimes or something, because Fitzpatrick, every time I say Fitzpatrick, I think of Comey's defense counsel. This guy's been brought in to handle motions having to do with the implementation of a filter protocol. So we have 3 judges to keep up with as regards this case so far. Okay. Comey's motion and memorandum in support of dismissal. This is the one that has to do with Cruz's questions being ambiguous and Comey's answers literally being true answers. I'm going to read this word for word without giving a lot of commentary. I already did a shorter video that's about 40 minutes long of me including other sources and video and all of those things. But I wanted to do a video where I went through this page by page. Okay. As explained in the accompanying memorandum, Count 1 seeks to punish Mr. Comey for responding to Senator Ted Cruz's fundamentally ambiguous questions with literally true answers. As a matter of law, neither those questions nor those answers can serve as the basis for a violation of 18 U.S.C. 1001A2. Thus, under long-standing principles of criminal law, Count 1 must be dismissed. If count 2 rests on the same allegedly false statements, it should be dismissed for the same reasons. And in any event, count 2 should be dismissed because it fails to give Mr. Comey adequate notice of the charges against him. Meaning that count 2 doesn't explain what the obstruction was. It doesn't have any factual information that characterizes how he obstructed, what the specific investigation was that he obstructed. There's no information. Count 1 of the indictment seeks to punish Mr. Comey for seconds of testimony he gave in response to compound and ambiguous questioning. But longstanding principles of criminal law make clear that the government cannot prove a violation of 18 U.S.C. 1001A2 unless it establishes that the defendant gave false answers to precise questions. Here the indictment conspicuously omits the lengthy, confusing questions that prompted Mr. Comey's testimony. Specifically, after speaking for more than a minute, Senator Ted Cruz asked Comey to recall statements that he had made 3 years earlier and to simultaneously address statements that Senator Cruz incorrectly claimed were made by Andrew McCabe, the former deputy director of the FBI. In doing so, Senator Cruz never indicated that he wanted Mr. Comey to address the statements or activities of any person except for Mr. McCabe. Viewed in context, Senator Cruz's questions cannot form the basis for a violation of Section 1001A2 because they were fundamentally ambiguous, and regardless, Mr. Comey's answers to them were literally true. Count 1 thus must be dismissed under Federal Criminal Procedure 12B3A, and count 2 should be dismissed for the same reason, to the extent it rests on those same alleged false statements, and for the independent reason that it deprives Mr. Comey of his right to notice the charge against him. Background. On September 4th, 2013 to May 9th, 2017, Mr. Comey served as a director of the FBI. As FBI director, Mr. Comey oversaw the FBI's operations, including investigations into national security threats and federal crimes involving terrorism, fraud, political corruption, gang violence, and cybercrimes. Among the many investigations at the FBI during Mr. Comey's tenure was Crossfire Hurricane, a counterintelligence investigation into alleged links between President Trump's 2016 campaign, not President Trump, and the Russian government, as well as the mid-year exam, an investigation begun in 2015 into then-candidate Hillary Clinton's alleged mishandling of classified information during her tenure as Secretary of State. On May 3, 2017, Mr. Comey voluntarily testified at the Senate Judiciary's Committee on Annual FBI Oversight Hearing. And then it links to the oversight hearing. As relevant here, Mr. Comey engaged in the following exchange with Senator Charles Grassley. Mr. Grassley: Director Comey, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? Never. Question 2. Relatively related. Have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton investigation? No. 3 years later, on September 30th, 2020, Mr. Comey voluntarily appeared before the same committee at a hearing on the Crossfire Hurricane investigation. Then it links to that hearing. As relevant here, Mr. Comey engaged in the following exchange with Senator Ted Cruz. Senator Cruz: On May 3rd, 2017, in this committee, Chairman Grassley asked you point blank, quote, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? You responded under oath, never. He then asked you, have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration? You responded, no. Now, as you know, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal, and that you were directly aware of it and that you directly authorized it. Now, what Mr. McCabe is saying, and what you testified to, this committee cannot both be true. One or the other is false. Who's telling the truth? Mr. Comey replied, I can only speak to my testimony. I stand by what the testimony you summarized that I gave in May of 2017. So your testimony is you've never authorized anyone to leak. And Mr. McCabe, when he says contrary, is not telling the truth. Is that correct? Again, I'm not going to characterize Andy's testimony, but mine is the same today. And then it links to those. The video clip and then the transcript are both filed as sealed exhibits, or not sealed exhibits, as exhibits. The colloquy thus reflects that Senator Cruz's questions focused exclusively on an asserted contradiction between Mr. McCabe and Mr. Comey. Footnote: compounding the ambiguity, Senator Cruz mischaracterized Mr. McCabe's actual statements in claiming a contradiction between Mr. McCabe's account and Mr. Comey's testimony. There is no record of Mr. McCabe ever stating that Comey authorized him to leak information to the Wall Street Journal, much less a record of repeated and public statements to that effect. Mr. McCabe was interviewed multiple times, and in none of those interviews did Mr. McCabe assert that he spoke in advance with Mr. Comey about his disclosure to the Wall Street Journal. Let me make sure that footnote doesn't continue. Yeah, it does. Rather, Mr. McCabe stated in his last interview that he informed Mr. Comey that he had leaked information after he had done so. Office of the Inspector General report, which we've gone through previously on this show. Indeed, more than 2 years before the hearing with Cruz and Comey, the DOJ's IG found that Mr. McCabe did not consult Mr. Comey before talking to news outlets. Back to the motion. Apparently, based on that testimony, the government has charged Mr. Comey with a 2-count indictment. Count 1 charges Mr. Comey with making false statements to Congress in alleged violation of 18 U.S.C. 1001A2. To prove that a defendant violated 1001A2, the government must establish 1, the defendant made a false statement to a government agency; 2, the defendant acted willfully or knowingly or willfully; and 3, the false statement was material to a matter within the jurisdiction of the agency. Here, the government attempts to satisfy those elements by alleging the following from the indictment. On or about September 30th, 2020, in the Eastern District of Virginia, the defendant, James B. Comey Jr., did willfully and knowingly make a materially false, fictitious, and fraudulent statement in a matter within the jurisdiction of the legislative branch of the government of the United States by falsely stating to a U.S. senator during a Senate Judiciary Committee hearing that he, James Comey, had not, quote, authorized someone else at the FBI to be an anonymous source in news reports regarding an FBI investigation concerning person 1, Hillary Clinton. That statement was false because, as James B. Comey knew then and there, he, in fact, had authorized person 3 to serve as an anonymous source in news reports regarding an FBI investigation concerning person 1. On October 15th, 2025, the government confirmed to the defense that person 1 refers to Hillary Clinton and person 3 refers to Daniel Richman. Additionally, although the indictment does not specifically reference Senator Cruz, Mr. Comey's exchange with Senator Cruz is the only part of the 2017 hearing that touched on whether Mr. Comey had authorized someone else at the FBI to be an anonymous source on news reports. Count 2 charges Mr. Comey with corruptly endeavoring to influence, obstruct, and impede a Senate Judiciary Committee investigation on or about the same date by making false and misleading statements before that committee in alleged violation of 18 U.S.C. 1505. The indictment does not specify which false and misleading statements Mr. Comey allegedly made and why they were allegedly false or misleading. Similarly, the indictment does not specify how Mr. Comey allegedly corruptly endeavored to influence, obstruct, and impede the committee's investigation, or even which investigation that was. All right, argument. Section 1001A2 authorizes the government to prosecute witnesses who mislead government investigators by giving materially false answers to clear questions. But it does not authorize the government to create confusion by posing an imprecise question and then seek to exploit that confusion by placing an after-the-fact nefarious interpretation on the ensuing benign answer. Indeed, basic due process principles in criminal law require that the questioner frame his questions with clarity so that the witness does not have to guess. Quote, the burden is on the questioner to pin the witness down to the specific object of the questioner's inquiry. See Braunston v. United States, 1973. Accordingly, precise questioning is imperative as a predicate for the offense of perjury, and a perjury status cannot be invoked so long as the witness speaks the literal truth. Applying those principles here, count one must be dismissed. Count one alleges that Mr. Comey made a false statement in response to Senator Cruz's questions at a 2020 Senate hearing. But those questions, which require Mr. Comey to recall statements he had made 3 years prior and simultaneously address another individual's alleged statements, were, quote, fundamentally ambiguous, and thus cannot support a conviction under Section 1001A2. Nor can Mr. Comey's literally true answers to those questions support a conviction. Fundamental to any false statement charge are both clear questions and false answers. Neither exist here. In turn, Section 1505 authorizes the government to prosecute a witness who, quote, corruptly or by threats or force, or by any threatening letter or communication influences, obstructs, or impedes a pending proceeding before a congressional committee. As noted, Count 2 alleges that Mr. Comey violated Section 1505 by making false and misleading statements to the Senate Judiciary Committee, but fails to specify which statements were allegedly false and misleading. To the extent Count 2 rests on the allegedly false statements as Count 1, it should be dismissed for the same reasons. And in any event, Count 2 should be dismissed because it fails to give Mr. Comey adequate notice of the charges against him. In answer to a fundamentally ambiguous question, this is the next section, Count 1 must be dismissed because it rests on particular interpretation of fundamentally ambiguous questions. An answer to a fundamentally ambiguous question may not, as a matter of law, form the basis for a false statement under Section 1001A2. See Mosby and citing Sawari. Those are precedent cases. Quote, the purpose of the rule of fundamental ambiguity is threefold, namely to 1, preclude convictions grounded on surmise or conjecture, 2, prevent witnesses from unfairly being the risk or bearing the risk of inadequate examination, and 3, encourage witnesses to testify, or at least not discourage them from doing so. See United States v. Farmer, 1998. To achieve those goals, courts have required near absolute clarity from the questioner in order to support a perjury charge, and have similarly applied that requirement to analogous false statements charges such as those here, United States v. Strom, 2011. Also United States v. Elfenbein, 2025, which explains that where relevant language is fundamentally ambiguous, a false statement conviction is impossible. A false statement charge that rests on a particular interpretation of a fundamentally ambiguous question must be dismissed. Whether a predicate question is, quote, fundamentally ambiguous is a question of law for the court to resolve before trial. See United States v. Chujoy, 2016. And then United States v. Ryan, 1987, abrogated on other grounds by United States v. Wells, 1997. Those explain that the question is fundamentally ambiguous. If it is fundamentally ambiguous, it is not amenable to jury interpretation, which that's important. This is not a question for the jury to decide. It's for the court to decide before trial. And if a court decides that the predicate question is fundamentally ambiguous, the charge must be dismissed if it does not allege that the defendant's answer was false under every interpretation of the question. See United States v. Serafini, 1999. Senator Cruz's questions at the 2020 Senate hearing were fundamentally ambiguous. A question is fundamentally ambiguous if there are multiple ways to interpret it, and men of ordinary intellect would not agree on which interpretation is correct. For instance, courts regularly deem compound questions fundamentally ambiguous when they make it difficult for a witness to tell which part of the question he should respond to. See United States v. Landau, 1990, United States v. Rendon Marcus, 1999. Other factors that bear on whether a question is fundamentally ambiguous include, quote, the context of the question and answer, and inherent vagueness of certain words and phrases, and defects in syntax or grammar in question, or in a question. Senator Cruz's questions are fundamentally ambiguous because people of ordinary intellect would not be expected to understand that he meant to ask a broad question about Mr. Comey's interactions with anyone at the FBI, including Daniel Richman, during a colloquy focused on Mr. McCabe. On the contrary, a reasonable person readily would have understood Senator Cruz to be asking only whether Mr. Comey had specifically authorized Mr. McCabe to be an anonymous source in news reports. 1. Senator Cruz's imprecise compound questions make it unclear whether he was asking about Mr. McCabe or FBI officials more broadly. When a government official combines two or more discrete inquiries in one question, but elicits a single response from the witness, it may be impossible to know which question the witness believed he was answering. That is exactly what Senator Cruz did at the 2020 Senate hearing. As relevant here, Senator Cruz asked Mr. Comey two questions, each of which contained a discrete inquiry about Mr. McCabe and a discrete inquiry about FBI officials more broadly. As a prelude to his first question, Senator Cruz described the 2017 exchange between Mr. Comey and Senator Grassley. On May 3rd, 2017, in this committee, Cruz said, Grassley asked you point blank, quote, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? You responded under oath, never. He then asked you, have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration? You responded again under oath, no. Senator Cruz did not stop and ask Mr. Comey whether his statements to Senator Grassley were true. Instead, he continued on to describe a statement by Mr. McCabe. Now, as you know, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and that you directly authorized it. Now, what Mr. McCabe is saying and what you testified to this committee cannot both be true. One or the other is false. He then asked, who's telling the truth? By structuring his question that way, Senator Cruz raised two issues. One, whether Mr. Comey was telling the truth in his 2017 exchange with Senator Grassley. And two, whether Mr. McCabe was telling the truth in what Senator Cruz incorrectly characterized as Mr. McCabe's recent statements. But instead of asking Mr. Comey to address each of those issues separately, he only asked Mr. Comey to address the question of whether Mr. Comey or Mr. McCabe was telling the truth. The compound structure of Senator Cruz's question, his second question, was nearly identical to the first. After Mr. Comey responded to the first question, Senator Cruz stated, quote, so your testimony is you've never authorized anyone to leak? Senator Cruz then paused and, after a moment, proceeded to ask a question. And Mr. McCabe, when he says contrary, is not telling the truth. Is that correct? By structuring his comment and question that way, Senator Cruz signaled to Mr. Comey that he should specifically address the question about whether Mr. McCabe was lying. By the way, I got to pause because I just want to really I pointed this out in my other video. But because Cruz references that exchange with Grassley, I think a lot of people, when they listen to that exchange, they take Cruz to be asking the same question as Grassley did, when Cruz wasn't at all. It's just kind of a funny thing about the way we communicate. And I don't think it's has anything to do with people being of being unreasonable or being of poor intellect or anything like that. I think it's just the way we communicate and the juxtaposition of Cruz citing a set of questions that were already asked of Comey years before. Oops. Just jumped a bunch of sections on the paper by I hit a button on my keyboard. Right. I think it's just the way we communicate, and people hearing that first part and those questions to Comey sticking in their mind, and then Cruz asking his own questions about Comey. So there's this juxtaposition of two different sets of inquiries, and people come away with thinking Comey's answer covers both sets of inquiries or something like that. And I think it's really easy to get confused like that. And it's a very human and forgivable thing. But when it comes to matters of law and charging someone for a false statement, as we've read in the case law that's been cited here, and the motion is arguing, you need clear questions of someone in order to succeed in prosecuting them with a false statement. It has to be clear questions and clear answers in order for it to be perjury or a false statement. And by the way, that's regardless of who the defendant is. Picture yourself as a defendant, and you get asked some questions by an officer, by an FBI agent or somebody, and you've been charged with lying to law enforcement. You damn sure would want those questions to have been absolutely clear. You know, you don't want it to be a perjury trap. You don't want it to be 3 questions loaded into one, and then they ask you something at the end and you say no, and then they charge you for lying about the second question in a series of 3 when you were only answering the third question, right? And that's kind of what's happening here, is that there's a recounting of previous questions and answers, and then compound questions from Cruz that are ambiguous about a specific, and they're about a specific person. And yet the indictment charges him with lying in testimony that's past the statute of limitations. But the indictment cites September 30th of 2020 as the day Comey made the false statement. But in their heads, everybody's thinking Comey lied back in May. See what I'm saying? It's like they've put that test. It's like the statute of limitations expired back in May, and then they've put that within this question here. It's I hope that makes sense. It is like convoluted, and that's the problem. The problem is it's convoluted, and it's ambiguous, and it's, furthermore, Comey said the literal truth. He stood by his testimony. Okay, back to this filing. Courts have regularly determined that similar compound questions are fundamentally ambiguous. In Landau, for instance, the government had asked the defendant, a general contractor whose work for a company had been delayed due to union picketing, whether he had told the company or its representatives that he, quote, had to make payments to the union, or that it was necessary because of the union's picketing that it cost you more money, end quote. The court held that the question was fundamentally ambiguous because it compounded 2 separate inquiries. One, whether the payments to the union were necessary, and whether the picketing cost more money, and elicited a singular response. Accordingly, the court concluded that the question could not, as a matter of law, support a perjury conviction, and dismissed the indictment. Now, how much less ambiguous and confusing is that question than what Cruz was asking Comey? Like, that is so much less ambiguous and convoluted than this set of questions from Cruz to Comey were. And yet this was dismissed. Similarly, in Rendon Marquez, the court determined that the following question on an immigration and naturalization service form was too ambiguous to support a conviction under Section 1001, the same section Comey's charged with. Quote, have you knowingly committed any crime or offense for which you have not been arrested, or have you been arrested, cited, charged, indicted, convicted, or fined or imprisoned for breaking or violating any law or ordinance including traffic violations. The court explained that the form, quote, asked two separate and distinct questions, but provided space for only one yes or no answer. So it could be, have you knowingly committed any crime or offense for which you have not been arrested? That's one question. And then the second question is, have you been arrested, cited, charged, et cetera, including traffic violations? Because it could be this one, but not this one, right? Or it could be this. Yeah, you could say yes to one and no to the other. Likewise, each of Senator Cruz's questions compounded two separate inquiries: whether Mr. Comey was telling the truth in 2017, and whether Mr. Comey had authorized Mr. McCabe to have been an anonymous source, but asked for the equivalent of a yes or no response only as to the second inquiry. Any reasonable witness would not have found it difficult to know that Senator Cruz wanted Mr. Comey to answer the binary question just asked, and also to address the prior comments. This is especially so where the questioner did not confront Mr. Comey with what the government is now claiming he then and there knew, which is the alleged conduct involving Mr. Richmond, but instead confronted Comey with an inaccurate account of Mr. McCabe's statements. Everything about the exchange narrows it to being focused on McCabe, and that Senator Cruz was inquiring about McCabe. Next part, 2. Senator Cruz's use of alternating narrow and broad questions reinforces that the line of questioning was fundamentally ambiguous. Even if Senator Cruz's use of compound questions did not by itself make those questions fundamentally ambiguous, context confirms that Mr. Comey could not have reasonably known that Senator Cruz was asking him to answer a broad question about anyone at the FBI when asked a specific question about Mr. McCabe. As noted, the context of the question and answer can establish that a witness could not have understood what he was being asked. Accordingly, the court must look to the context of the defendant's statement to determine whether the defendant and his questioner joined issue on a matter of material fact to which the defendant allegedly uttered a false material declaration. As relevant here, context can establish that a defendant would have understood a facially broad question to have a much narrower focus. The Third Circuit's decision in Serafini, which affirmed the district court's pretrial dismissal of a perjury charge, is instructive. As part of an investigation into that's going to give an example here. As part of an investigation into a suspected campaign finance violation, the government asked the defendant a series of 3 questions about a $2,000 check he had received from his nephew, ostensibly as a reimbursement for his $1,000 donation to Bob Dole's presidential campaign. Question 1, is there any check that you received that reimbursed you other than the $2,000 check for your contribution? No. Is there another check that you were aware of that is connected to this investigation, to this Dole contribution, other than the $2,000? Answer, not other than what you have shown me today. No. Question 3, did you receive any other money, whether by cash or check or any other form, from Michael at or around the time period you made your Dole contribution other than this $2,000 check? Answer, I can't specifically remember. However, we transfer money back and forth quite often for different reasons, and I can't honestly say that there wasn't some kind of transfer. I mean, we do it all the time. After discovering that the $2,000 had served to reimburse both the defendant and his aide for respective $1,000 contributions, the government charged the defendant with making a false statement in response to question 2. The government claimed that question 2 had asked the defendant to identify any other check he was aware of, and that he had been aware of at least 2 others: the aide's check to the campaign and his check reimbursing the aide. The Third Circuit held that question 2 was fundamentally ambiguous because, quote, read in context, the question takes on a particular meaning wholly at odds with the broad, open-ended significance the government now seeks to attribute to it. The court explained that although question 2 could in isolation be interpreted as asking whether the defendant was aware of any other checks, the government's antecedent and subsequent questions focused on whether the defendant had personally received any other reimbursement checks. Given the narrow subject matter of those questions, the court explained, the defendant could easily have interpreted the sandwich question, question 2, to ask whether he had personally received other checks from his nephew besides the $2,000 check. Indeed, the best way for the defendant to, quote, inject into the question sufficient intelligibility so that he could reply was to treat the question as referentially sequential to questions he had just answered. Context thus showed that the defendant would not have understood the question to have the limitlessly capacious construction the government would have it bear. Context shows that the question at issue here in United States v. Comey were even more ambiguous and unfair than those in the case of Serafini, as Mr. Comey was expressly invited to answer only the narrower questions. As explained above, Senator Cruz began by summarizing Mr. Comey's response to Senator Grassley's broad question about whether Mr. Comey had, quote, ever authorized someone else at the FBI to be an anonymous source in news reports. But Senator Cruz then narrowed his focus, incorrectly asserting that, quote, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and that you directly authorized it. Accordingly, when Senator Cruz asked Mr. Comey to address who's telling the truth, the best and perhaps only way for Mr. Comey to inject into the question sufficient intelligibility so that he could reply was to, quote, treat the question as referentially sequential to Senator Cruz's immediately antecedent assertion about Mr. McCabe. In other words, a reasonable witness most readily would have understood Senator Cruz to be asking him to specifically address whether he had authorized Mr. McCabe to serve as a source to the Wall Street Journal. Similarly, although Senator Cruz began a second question by referencing Mr. Comey's general statement that he had, quote, never authorized anyone to leak, he again narrowed his focus, asking, quote, and Mr. McCabe, if he says contrary, is not telling the truth, is that correct? Context thus underscores that count 1 rests on a fundamentally ambiguous question. As the indictment frames it, Senator Cruz's question was whether Mr. Comey had, quote, authorized someone else at the FBI to be an anonymous source in news reports. But that quoted language is taken from a statement by Senator Cruz that is a preface to the question that followed 4 seconds later. When fairly read in context, the question takes on a particular meaning wholly at odds with the broad, open-ended significance the government now seeks to attribute to it. Specifically, that context suggests that Senator Cruz was asking only about whether Mr. Comey had authorized Mr. McCabe to be an anonymous source to the Wall Street Journal. Pause. I gotta say, it even takes on a little bit more of that characteristic when you know that Mr. McCabe had been found guilty, or not found guilty, had been found at fault just 2 years prior to this, specifically for leaking to the Wall Street Journal anonymously through Lisa Page for this article right here from October 30th, 2016. And he had lied about it multiple times. He lied to Comey about it. He lied to INSD investigators about it. And he lied to the IG about it. And he got caught because IG Horowitz got Lisa Page's text messages and proved it, that McCabe had been the source of the leaks in this article and he had made them anonymous, used Lisa Page as an intermediary. And we went through that on a previous episode. But knowing that, when Cruz is asking about Mr. McCabe being an anonymous source to the Wall Street Journal, what comes to mind? This article. And Comey, in the first week of November 2016 had specifically asked McCabe about this article and who leaked to it, and McCabe pretended not to know. So all of that information just colors in that in the moment of this line of questioning from Cruz, it makes even more sense that Comey is going to understand Cruz to be specifically asking about this instance of this article, which was investigated and already figured out 2 years prior that McCabe did it on his own. Part 3. Senator Cruz's questions were riddled with other ambiguities that would have made it difficult for any reasonable person to understand them. Senator Cruz's focus on Mr. McCabe is alone sufficient to establish fundamental ambiguity when measured against the government's current interpretation. But there is more. Senator Cruz's questions were riddled with other ambiguities that would have made it difficult for any reasonable person to understand them in the moment. For instance, Senator Cruz asked Mr. Comey to affirm or deny prior testimony that he authorized, quote, someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration. As of May 3rd, 2017, there was no Trump investigation, but rather than an investigation into whether there were links between 4 individuals associated with the Trump presidential campaign and Russia, as I've been telling you guys for years and years and years. I've been telling you for years and years. Oh, that exact thing. Let's see, what are these footnotes? Oh yeah, it adds that Mr. Comey voluntarily agreed to testify at this particular hearing on the understanding that the topics of questioning would be limited to 4 topics, none of which related to the mid-year exam investigation involving Hillary, which isn't that big of a deal, but it's worth pointing out that they sent Comey the 4 topics they were going to be talking about this hearing, and then they ended up asking him about other things. All right. In the Clinton investigation, the Clinton administration had ceased to exist some 17 years before. Senator Grassley's original question in 2017 was about the Clinton investigation, not the administration. Senator Cruz's use of the words never and ever injected additional ambiguity. Courts have explained that questions asking witnesses to recall whether they ever have done something are ambiguous because it is difficult to answer them without a perfect memory. See United States v. Brazia, 1973. Questioners can avoid such ambiguities by focusing the witness's attention on a particular day or time, which in a sense Cruz did because he focused him on McCabe and Wall Street Journal, right? Accordingly, when Senator Cruz referenced Senator Grassley's question asking whether Mr. Comey had ever authorized someone else at the FBI to be an anonymous source in news reports, he made it even more difficult for Mr. Comey to understand what he was asking. Finally, when Senator Cruz referenced Senator Grassley's questions about whether Mr. Comey authorized someone else at the FBI to serve as an anonymous source, there was no reason to assume that he was referring to anyone but full-time employees like Mr. McCabe, who were stationed at the FBI, as opposed to someone like Mr. Richmond, who was a special government employee living full-time in New York. Senator Cruz's errors are a form of imprecision whose consequences must be laid at the table of the questioner, not the questioned. And I don't think this is any small point. Richmond, for a time, was a special government employee hired by Comey, but he wasn't a full-time employee of the FBI. But it kind of doesn't even matter because Cruz didn't ask him about that. Cruz narrowed it to being about McCabe and kept refocusing it on McCabe. And Cruz didn't, like I said earlier, Cruz is not re-asking the questions that Grassley had asked 3 years prior. In order for this indictment to really make sense, Cruz would have needed to be asking or re-asking the same questions that Grassley had. And that's not what happened. He asked him about McCabe specifically. Count 1 rests on a particular interpretation of Senator Cruz's fundamentally ambiguous questions and thus must be dismissed. Persons of ordinary intellect could and likely would have understood Senator Cruz to be asking Mr. Comey whether he authorized Mr. McCabe to serve as an anonymous source to the Wall Street Journal. Thus, because there is no allegation that the question so understood, Mr. Comey's answer was false. Count 1 should be stricken. The indictment alleges that Mr. Comey's statement was false because he, in fact, had authorized Person 3 to serve as an anonymous source in news reports regarding an FBI investigation concerning Person 1. On October 15, 2025, the government confirmed to the defense that Person 3 refers to Daniel Richmond and Person 1 refers to Hillary Clinton. But as noted, a reasonable person could have understood Senator Cruz's questions to be entirely unrelated to Mr. Richmond or anyone else at the FBI, and to have focused on Mr. McCabe alone. On that reasonable understanding, the indictment contains no allegation that Mr. Comey's answers were false. It never alleges that Mr. Comey made a false statement regarding Mr. McCabe. On the contrary, the indictment omits Senator Cruz's statements about Mr. McCabe, obscuring the context necessary to understand both the questions themselves and Mr. Comey's responses. The indictment thus impermissibly lifts statements of the accused out of its immediate context and gives it a meaning wholly different than that which in context it clearly shows. As a result, Count 1 cannot be sustained. 2. Mr. Comey's literally true answers separately warrant a dismissal of Count 1. Regardless of whether Senator Cruz's questions were fundamentally ambiguous, the court should also dismiss Count 1 because Mr. Comey's answers were literally true. Where a witness's answer is not responsive to the question asked, it cannot serve as the basis for a false statement's charge if it was literally true under any interpretation of the question. See United States v. Smith, 2022. Skip part of that citation. Although the literal truth defense is a narrow one, the Fourth Circuit has dismissed numerous perjury and related charges based on a defendant's literally true answers. And it gives a bunch of examples here, which I'm going to skip, but it cites a bunch of ones that were dismissed. Here, Mr. Comey's answers to Senator Cruz's questions were literally true. When Senator Cruz's preliminary statements are omitted from the questions and answers, it is apparent that the senator posed two questions to Mr. Comey. The first question was between Mr. Comey and Mr. McCabe. Who's telling the truth? A direct answer to this question would have required Mr. Comey to respond either, I am telling the truth, or Andrew McCabe is telling the truth. Mr. Comey, however, did not respond by stating who was telling the truth. Instead, he stated, quote, I can only speak to my testimony. I stand by the testimony you summarized that I gave in May of 2017. Although those statements did not respond directly to Mr. Cruz's question, they were literally true. Mr. Comey could only speak to his own testimony. He could not read Mr. McCabe's mind and know whether Mr. McCabe intentionally lied in the statements described by Senator Cruz. This is all the more true where Senator Cruz cited statements that Mr. McCabe simply had not made. Likewise, Mr. Comey's statements that he stood by his prior testimony was truthful, regardless of whether that prior testimony was itself truthful. The same, which by footnote, Mr. Comey firmly maintains that his prior testimony was truthful, but for purposes of the literal truth defense, the truthfulness of the prior testimony is irrelevant. Mr. Comey can truthfully stand by prior testimony, even if the government were correct, and it is not, that the prior testimony was false. Accordingly, the statement that Mr. Comey stands by his prior testimony cannot serve as the basis for a false statement charge. The same is true of Mr. Comey's answer to Senator Cruz's second question. Senator Cruz asked, quote, so your testimony is you've never authorized anyone to leak, and Mr. McCabe, when he says contrary, is not telling the truth. Is that correct? A direct answer to this question would have required Mr. Comey to state either correct, Andrew McCabe is not telling the truth, or incorrect, Andrew McCabe is telling the truth. Mr. Comey said neither of those things. He instead stated that he was, quote, not going to characterize Andy's testimony, but mine is the same today. Again, that response is literally true. Mr. Comey, in fact, did not characterize Mr. McCabe's testimony, and his statement that his testimony is the same today simply meant that he did not intend to revisit his prior testimony. That was a literally true statement, regardless of whether the prior testimony was itself truthful. Further, as detailed above, Senator Cruz's questions referenced whether Mr. Comey authorized anonymous sources to report on the Trump investigation, which did not exist during his tenure as FBI director, and the Clinton administration, which had ended nearly 17 years earlier. So Mr. Comey's answers to the questions were literally true, and the government cannot incorrectly rewrite his responses to form a false statements charge. Ignoring those details, the government presented an indictment to the grand jury that misstates Mr. Comey's testimony. But if a person cannot be charged by, quote, the device of lifting a statement of the accused out of its immediate context, and thus giving it a meaning wholly different than that which its context clearly shows, he certainly cannot be charged where the statement lifted out of context must be rewritten to claim that it is false. In sum, although Mr. Comey did not respond directly to Senator Cruz's questions, his responses were literally true. Section 1001A2 does not criminalize non-responsive testimony. It criminalizes only false testimony. And Mr. Comey's testimony here cannot plausibly be characterized as false. Of course, Senator Cruz could have followed up by asking for clearer answers, or he could have reframed his initial questioning with greater precision, or Senator Cruz could have asked Mr. Comey about other specific individuals, including Mr. Richmond, but he did not. And that is what the questioner must have done if the government wishes to prosecute the defendant. The questioner must press on for the information he desires. The government cannot now correct his failure by a prosecution for making a false declaration. Accordingly, regardless of whether Senator Cruz's questions were fundamentally ambiguous, Count 1 should be dismissed on the independent basis that Mr. Comey's answers were literally true. Part 3. Count 2 should be dismissed for similar reasons. Count 2 alleges that Mr. Comey violated Section 1505 by making a false or misleading statement to the Senate Judiciary Committee. The indictment does not, however, specify which false and misleading statements Mr. Comey allegedly made, why they were allegedly false or misleading, or even which investigation he allegedly endeavored to corrupt. To the extent Count 2 rests on the same false statements as Count 1, that count should also be dismissed for the reasons set forth herein. But as it stands, Count 2's lack of specificity renders it inherently and separately defective for failing to provide adequate notice to Mr. Comey of the charge against which he must defend. Such notice is of paramount importance here because of the broad scope of the relevant congressional hearing and the many topics covered in prolonged testimony. The government cannot try Mr. Comey on cherry-picked statements from a 4-hour hearing without specifying which statement it believes is false or misleading. And surely the government does not believe that it may secure an indictment based on one statement placed before the grand jury and then switch to a different statement at trial. That tactic would defeat the purpose of the grand jury performing its charging function. It also provides yet another reason for the disclosure of the grand jury proceedings, which is another motion they filed, and it is further basis to grant Mr. Comey's concurrently filed motion for a bill of particulars, which we're going to read next, I think. Accordingly, the lack of specificity in Count 2 deprives Mr. Comey of his right to notice of the charge against him, and that count is subject to dismissal on that deficiency alone. Conclusion: for the foregoing reasons, the indictment should be dismissed with prejudice. I think that's a very compelling filing, and I don't really know how the government gets around that, how the prosecution is going to square this. But I look forward to reading their filing that attempts to do so and seeing if I'm persuaded by it. Could happen. Okay, continue our coverage of filings on the Comey docket, which is super active this week. Lots of stuff to cover. I think this is going to be the last one, at least for now, that is a motion from Comey. The next filings we're going to get into on the following videos and in the rest of episode 351 of my podcast is going to be responses from the DOJ, the prosecutors filing, and their stuff is really compelling, and I'm looking forward to covering it. So this is going to be the last one from Comey's side for now, and it's a motion for a bill of particulars. A bill of particulars in either a civil or criminal case is basically asking the other party to tell you exactly a written account of an itemized account of exactly what it is they're charged with. And that's what Comey is asking for here. And it makes a lot of sense because the indictment against Comey is super short on any specific information about what it is he's charged with. And he, as they've complained in other filings, and if we go and look at the indictment, this is all it is. It's just these pages right here, these 2 pages, 2 counts, and it doesn't tell you anything about the how. It tells you the when, September 30th, 2020, but it doesn't tell you the how, the what. It tells you person 1 and person 3, which we now know from other filings are Hillary Clinton and Daniel Richman. But that's about it. And it's not enough information in order for the defendant, James Comey, to create a defense for. How can you create a defense against such little information here? So that's what the bill of particulars is asking for. And I'm not going to read the whole thing page by page. For this one, we're just going to go real quick. Says then gives the background of it. It bears noting that both of the counts of the indictment appear to focus on mere seconds of Mr. Comey's testimony to the Senate Judiciary Committee at that hearing. And at that hearing, Comey provided nearly 4 hours of testimony in response to a range of questions. And given the lack of details, essential details, that are in the indictment, Mr. Comey cannot prepare a defense to this indictment. If the indictment survives dismissal, which there are 4 motions to dismiss now, I think, a bill of particulars under Federal Rule of Criminal Procedure 7F is warranted. Now, this is what I want to dig into, is what those particulars are. As to count 1, Comey is asking for DOJ to identify the date, time, and method of communication for each instance in which Comey allegedly authorized Mr. Richman to act as an anonymous source regarding the Clinton investigation. That's pretty interesting because it's the thing that Mr. Richman said never happened. Has Mr. Richman been a source in news reports? Yes. Have those news reports talked about the Clinton investigation? Yeah. Have those news reports talked about the Trump investigation? Well, they may have, but there was no such thing as the Trump investigation. Not at the time of Comey was FBI director, and not at the time that Mr. Richman was speaking back then. The relevant time period, Trump wasn't under investigation. So, and Mr. Richman says Comey never authorized him to be an anonymous source. In fact, in all the newspapers I'm aware of, Mr. Richman is not an anonymous source. He's a named source. So this is highly interesting what the government will say about this right here, because that might be some brand new information to us anyway. B, the individuals or entities to whom Mr. Comey allegedly authorized Mr. Richman to act as an anonymous source regarding the Clinton investigation for each instance identified above. So who did he talk to? What news reports? What did those news reports say? What are those news reports? They're not named anywhere in here or in any filing so far. The substance and form of Mr. Comey's communication. This is the next one. The substance and form of Mr. Comey's communication allegedly authorizing Mr. Richman to act as an anonymous source regarding the Clinton investigation for each instance identified in 1A. So was it electronic communication? Was it email? Was it text? Was it verbal? Was it over the phone? What was it? Next, each instance in which Mr. Richmond allegedly provided or attempted to provide information to a news publication as an anonymous source. I can find lots of articles where Richmond is a named source, but that's not the allegation here. The allegation is that he served as an anonymous source, and then Comey lied about that occurring. The individual lied about it occurring on Comey. Wait, let me restate it. You need to be careful. The allegation is that Comey authorized Richmond to serve as an anonymous source in news media that mentioned the Clinton investigation, articles that had to do with the Clinton investigation. So what are those instances where that happened? The individuals or entities to whom Mr. Richmond allegedly provided or attempted to provide information to a news publication as an anonymous source for each instance identified above. And then for count 2, which is the obstruction one, each allegedly false or misleading statement that underlies the count 2 charge. The specific question leading to and answered by Mr. Comey that underlies each statement in count 2. The factual basis for the government's allegation that each statement identified in response above was false when it was made. The factual basis for the government's allegation that Mr. Comey knew that the statement identified in response above was false when he made it. How Mr. Comey corruptly influenced the proceeding. Which inquiry or investigation Mr. Comey allegedly attempted to influence by the Senate Judiciary Committee, and specify any other ways in which Mr. Comey allegedly violated 18 U.S.C. 1505, which is the obstruction of a congressional investigation. So the purpose of an indictment is twofold. It needs to indict a person. Actually, I'm going to skip all that stuff. This is all the legal argument here. Arguing about when a bill of particulars is necessary or required or whatever. I don't think there's really an argument that one isn't required here, because the indictment is so light on any details. It doesn't really tell you anything. And it, as we learned in the other filing we covered, or you read through, it gets things wrong. Like, it's just straight up, it has flaws, has errors in it. Let me skip all this. There we go. This is the next part I wanted to get to. Yeah. Okay. Count 1 fails to provide any detail regarding the factual basis for its claim that Mr. Comey knowingly authorized Mr. Richmond to be an anonymous source in news reports regarding the Clinton investigation, including A, when and how Mr. Comey provided such authorization, and B, what Mr. Comey authorized Mr. Richmond to speak to news reporters about, and C, which news reports included anonymous information from Mr. Richmond. Footnote. Always check the footnotes. What does footnote 4 say? Although the Arctic Haze investigation identified several instances in which Mr. Richmond allegedly provided information to the media, the indictment does not indicate whether those instances are the basis for the charge here. The government produced more than 85,000 pages of discovery that include, among other things, but some not all, of the materials obtained from a wide-ranging FBI investigation across different districts and numerous articles, some of which quote Mr. Richmond by name. The voluminous discovery provides no greater clarity to Mr. Comey for any aspect of count 1. The nature of the allegation underlying the government's apparent theory of falsity, that Mr. Comey authorized Mr. Richmond to be an anonymous source for an unnamed news outlet, places Mr. Comey in an impossible position. To effectively mount a defense, he must identify every article across the world at any time after 2015, when the FBI's investigation of Hillary Clinton began, that references an anonymous source about any aspect of an investigation involving Hillary Clinton, and discern whether the government contends that Mr. Richmond was the anonymous source for that article. Accordingly, without knowing whether and how Mr. Richmond allegedly acted as an anonymous source, Mr. Comey cannot ascertain whether the government has fulfilled its obligations under Brady. For example, if the government contends that Mr. Richmond acted as an anonymous source in articles that were the subject of the Arctic case investigation, the defense would request that entire investigative file, which has not so far been produced, as well as information about all other individuals the government identified as possible sources of information, which has also not been produced. Footnote: as explained in the motion to dismiss, Arctic case was an investigation to whether Mr. Comey allegedly disclosed classified information to the news media through Daniel Richmond. And that was concluded without criminal charges against Mr. Richmond or Mr. Comey. Such materials would enable the defense to demonstrate, as government investigators previously found, that there was insufficient evidence to believe that Mr. Richmond was the source of that information. And by contrast, if instead the government contends that Mr. Richmond was authorized to act as a source in a different article, the defense could tailor both its Brady request and trial defense accordingly. The defense should not be required to dig through tens of thousands of pages of incomplete discovery to guess at what it is defending against, only to be sandbagged by the government at trial. The government's failure to articulate how Mr. Comey's response was allegedly false prevents the defense from understanding the specific basis of the alleged violation. Under these circumstances, count one of the indictment does not allow Mr. Comey to assess whether the government has complied with its obligations to turn over materials under Brady, let alone to mount an effective defense for trial. It's going to be similar for count two. This is... I want to see if there's anything here I want to bring up. Okay. Sorry, I'm just scanning. In short, to be able to defend Mr. Comey, they need to know the substance of the charges asserted by the government. Yeah. Okay. What really caught me out my eye here is this stuff about Arctic haze, because we might learn through this or get access to the rest of the Arctic haze file. And we also might learn information as to all the other individuals the government identified as possible sources of information. That would be fun. That, because there's no doubt that some classified information got out. There is doubt about who it came from. And the Durham team, the investigators from Durham, and the U.S. Postal Inspection Service that were Tropic Vortex, and the other, I think, Washington Field Office, and there were other offices involved that were looking at the media leak investigations. The 8 of them that there were, I think. They had trouble tracking down who was leaking this classified information out, and it was getting out in a way in which it allowed the media to characterize their news reporting alongside the ICA that was weaponized against Trump, and to keep painting the picture of Trump-Russia collusion. And these leaks, I think the only one that they really did track down was this one from March 5th, 2017, where they figured out that it was James Baker and James Rybicki. Rybicki forwarded to James Baker a draft of a statement of Comey asking the DOJ to speak about Trump's wiretapping claim and tell the media that he wanted DOJ to state that the FBI had not wiretapped President Trump because Trump wasn't under investigation. And a draft of that was conveyed to the New York Times through James Baker, and James Baker said he thought that he was being told to do that and he was authorized to do that, and that was conveyed to him by James Rybicki, Comey's chief of staff. But there was nobody was ever charged for that because it was never concluded that Comey actually instructed or authorized anyone to share that. And this was another leak, that draft of that leaking. I think that's the only one that really came close to like really tracking down how it happened, and no charges were brought. Now, whether that's because it was a misunderstanding or because it got out some other way, like say McCabe leaked it out, I'm not sure. But this bill of particulars, we might learn some really, really interesting things from it. And it is necessary. We're going to see this. I'm pretty confident this is going to happen. This happened we've seen in other cases we've covered motions for bill of particulars, and what they've come back is like the government just comes back and details the defendant did this on this date. This is what they said. This is who they said it to. This is how they said it, or this is the action they took. This is how they went about that action. Here was their purpose in it. This is how it resulted in a crime. It's very pointed like that. And it's like an itemized accounting of the crimes, which is not there. It's not in the indictment. And you can't imagine trying to write your defense and plan out a defense to this right here. I mean, this is not possible. All right, in the next episode, or the next video I do, I'm really excited about, because we're going to get to the government's filings. The government has made several filings in United States v. Comey this week, and all of them are good. All of them contain new information and are a good read. All right, have you enjoyed all those documents? I recorded quite a few videos that haven't all been released as of this episode being published. And so episode 352 of the Just Human podcast is going to follow on shortly. I'm going to release it, I think, on Thursday. And I think what makes sense for me to do is release this one on Wednesday, and then on Thursday and Friday each release an episode. And there's big filings by DOJ on the docket. There's the next one, what's going to start off on episode 352 will be this one, the response and opposition. Yeah, this one right here, which is DOJ and United States consolidated response to motions to dismiss the appointment based on the unlawful appointment of Lindsay Halligan. And this is a joint response or consolidated, that's been filed with a attorney from AG Bondi's office and from the prosecutors in the EDVA who are handling the Letitia James case and the James Comey case. And this filing it's 32 pages. It's really long. It's a long read. My reading of it ended up being over an hour. So I'm just going to make it its own episode. And it's that important anyway. It's this issue of Halligan's appointment I've talked about quite a bit, and I've changed my mind. I have changed this filing right here has changed my mind on her appointment. And I'm ready to admit I got it wrong. I've been swayed. So don't ever accuse me of not being willing to change my mind. I'm very willing once I get a really good argument and some really good documents. So that's going to be in the next episode. I'm just going to make it just about that I think. So that'll do it for this one. If you guys enjoy it, if you're enjoying this coverage, let me know, and make sure you're following me. All the places that I'm at, go to my link tree. You can find all those places, and I would appreciate a show of support, of course. After all this reading that I've been doing, and as active as this docket is, I need more coffee. It's actually true. Right now I'm out of coffee. I have enough coffee for tomorrow morning in my cabinet. That's how much is left in my bag. I have enough beans to grind up for my coffee for tomorrow morning. And then I got to head out and go source some more gourmet coffee. So I'd really appreciate you contributing to my coffee fund by making a purchase one of my affiliate links, or just going to ko-fi.com or subscribing at justhuman.substack.com for $7 a month. You can keep me caffeinated, and you can keep the documents flowing. Thank you to everybody who supports the show and shares it, likes it, all those things. And thank you to everybody who is following me over on YouTube and has kicked me past 500 subscribers. Awesome. Really glad to be there. Your likes and your comments on my videos over there help me out. And if you're liking the shorter videos I'm doing, I would appreciate that feedback. I think ideally, I think the kind of the two types of content that I need to do is like a shorter form and then the long form that you guys are used to. Don't worry, I'm not going to stop doing that. But I think I want to feed both those appetites. And then there's a third form of content, which is a series of episodes reviewing a very important case. I teased that in the summer that I had a side project I was working on. That was going to be episodic. It was going to be covering an important court case, and we were going to go through transcripts, and I was going to tell the story of the case. I have not pushed anything out on that yet, but I have not forgotten it. It's still there. It's still a side project that I'm working on, but I'm trying not to be too much of a perfectionist about it, but I want it to be, I want it to be of a higher craft than what I tend to do. So like this stuff, like this episode and the content I usually do, you know, it's me talking into a mic and flipping through browser tabs and reading these documents and stuff. I want to put a little bit more production into the next one. Don't worry, it's not going to be super pro. Actually, it's going to be super pro in the sense that it's going to be my kind of super pro. But I just want to level up. I want to level up what I do, and I want to take my time with it. And yeah, anyway, so I'll get off of that because I'm going to say too much. I want to keep it close to my chest a little bit, and then when I put it out, I want you guys to be impressed. That's what I want. All right. So thank you, everybody. Really appreciate your support and all that you do for me. And I love doing this, and I'm really enjoying United States v. Comey. I'm really enjoying it. I'm enjoying having my mind changed on some things. And there's way more filings that have come in while I've been recording this episode. So I got to end this one so I can immediately start recording the next. Y'all stay human out there. I'll see you on the next one.